Chapter 36 is far more complicated than the prior two chapters in our series on business entities, and my apologies for the length of this discussion, as I do try to limit the videos for your time needs. Corporate governing, corporate function, and formation will keep our heads spinning for at least two chapters. And as I mentioned in my welcome letter in Module 0, the approach here asks that you learn vocabulary and concepts in order that you're able to speak with your company's attorney, not to make you into one. This area, though, is very complicated, and so I expect there will be several red lights when you meet this intersection of your business interests and the law. A red light signals it's time to pick up the phone and contact corporate counsel for direction, whereas a green light means simply to proceed without counsel. When you create your own entity, you're not the business in a solo as you would be in a solo proprietorship. In other words, you're not the corporation. The corporation is not you. You, however, are essentially giving birth to a child that can't vote or procreate, but has all other individual rights. So let's review the textbook frequently through this discussion for our definitions to provide us brief guidance. Definitions in this chapter are key to understanding the following chapters. And any specific questions you have, please feel free to email me. The nature of a company is that it is a person, but not a corporal one. The corporations can act in many ways and even have First Amendment free speech rights. A company can employ others, it can own property, invest, pay taxes. Companies can do many things, but it cannot adopt people, natural people that is, and fortunately it cannot vote. This vehicle that we create, mainly by state incorporation, shields investors or stockholders, but it can be dissolved by state law, as we'll talk about later. If a corporation is a sham, in other words, it has no sufficient capital, it protects just one or few shareholders, the creditors of that company may seek to pierce the corporate veil or to lift that veil, or in some ways to show that it's a sham or a shell company. The stockholders would lose their shield. Thus, states do not permit companies, for the most part, to form or to incorporate merely to divest creditors of what is due them. The state courts have the ability to lift that protection and make the incorporators, or in some cases the shareholders, the people responsible, indeed, as sole proprietors would also be responsible in a similar situation. As an attorney, I handled one case in which my client, a creditor, sought to pierce the corporate veil and make the principal and sole shareholder, which was also the company's president, personally liable for the debts. It was rather difficult to convince the court that the company was set up to fail, but eventually we got to a point where the owner of the company, the president that is, realized the court was going to pierce the veil and make him personally liable for the debts. And at that stage, he moved to settle the matter, which my client was willing to do.